Hello, my name is Stephen Gallagher and I'm from the Faculty of Law at the Chinese University of Hong Kong. And this is the first of two videos to give an introduction to the subject of shipwrecks, pirates, treasure hunters, and underwater cultural heritage protection. So really it's talking about the law to do with shipwrecks. I've broken the videos into two because there is so much to cover here. I usually cover this with my students in a 3-hour session, so feel very sorry for my students. It's an introduction to the topic. I will at times refer to the fact that I would cover this in more detail in a class on my master's course at CUHK Law. But again, if anyone has any questions about this, then my email is at the end. I'm very happy to follow up with any of these points. So the first video deals with the domestic laws, the laws of jurisdictions to do with what happens if people do discover shipwreck, treasure, pirate treasure. And really that's the law of salvage. So we'll be talking about really mostly the law of salvage. So I think most people find that the topic of pirate treasure fascinating. And that's why it's the subject matter of so many great films. And it's not just the treasure aspect of wrecks and underwater cultural heritage that is important. Of course, it's the knowledge that we get from these shipwrecks. We've seen many stories in recent years as technology has developed about the discovery of wrecks. So back in October of 2018, as part of a survey of the Black Sea, it was announced that the world's oldest, it should say intact, shipwreck had been found. So here we see this one there, about 2,400 years old, remarkable preservation. A form of ship that we only really knew before from illustrations on vases like the siren vase in the British Museum. So this is part of the importance of underwater cultural heritage, of shipwrecks, of the discovery of treasure. It's not just the intrinsic value of whatever is found, it's the knowledge that we actually get from it as well. And as technology has advanced, that's allowed us to find evidence of human exploration of the seas, of use of the seas, the trading on the seas, in ever more difficult terrain. So again, back in 2015, as part of a survey of the Indian Ocean in the search for the missing Malaysian airline, this wreck was discovered more than 2 miles below the surface of the sea. It's incredible that this was actually discovered, and the images that we're getting are so strong that we can actually picture this ship lying at the bottom of the ocean, and that's been very worrying. The developments in technology are very worrying for archaeologists, for those who are concerned with the protection of this underwater cultural heritage, because of course, as the technology develops, as it becomes not easy, but easier to reach these shipwrecks, to identify them, to find them, to identify them, to reach them, well then of course there is this worry about the disturbance of them, the recovery of them, particularly because they are seen as being of value, even as an intrinsic value, for the materials that actually make up the wreck itself. We'll come to that in the second video. Of course, when we think about shipwrecks and we think about treasure, we're really thinking about shipwrecks like this. This is an illustration, a picture of the seabed, which is meant to show debris from the wreck of the San Jose, sunk in 1708. It was a Spanish vessel that sank in a confrontation with some British vessels. I'm afraid that a lot of the wrecks we talk about are, well, they're either British vessels or the results of confrontations with British vessels, but meant to be carrying gold, emeralds, a treasure perhaps worth today something like $17 billion US. And of course, instantly we start thinking about values like this, about the fact that this is at the bottom of the ocean. Of course, the issue then becomes, who does it belong to? For lawyers, we start thinking about, wow, what sort of legal issues comes up with disputes involving this? Who's going to claim this? You know, can the British claim it? They sank the vessel. Can the Spanish claim it because it was a Spanish vessel? What about where the emeralds and the gold came from? What about the waters that actually, you know, who has control of these particular waters as well? So those are the legal issues that usually surround discovery of a shipwreck or of underwater cultural heritage and treasures. So that's what we really want to be talking about today. One thing that's always forgotten with these shipwrecks, by the way, or often is forgotten with these shipwrecks, is the fact that many people died in this wreck. So these sites, again, an argument is there that these are underwater burial sites. You know, people died in this wreck, and certain respect should be shown to the sites as well. But again, we can touch on that when we come to later aspects of the law concerning underwater cultural heritage. So why is it important then? Well, underwater cultural heritage, shipwrecks, treasures, underwater cities, the vestiges of human achievement underwater is very important, often because it's remarkably well preserved. Because, well, it may have been eroded by the water, it may have been eroded in other ways and affected, but one of the worst things to affect cultural heritage, treasure, if we think about archaeological sites around the world, it's humans. We are the worst at damaging these sites. And of course, these wrecks, by their very nature, if they're at the bottom of the sea, they've usually been, well, untouched by humans. There may have been, and there usually were, attempts to salvage, because we're talking about things of great value, the valuable cargoes, the ships themselves, parts of the ships, all of these things. But often they're there because they were difficult to get to. So they are remarkably well preserved. Today, they give us knowledge. They are, of course, treasure. But of course, there's another element that makes these important today, the political significance of them as well. And we'll talk about that more in the second video as well. So what law may apply if a shipwreck is found today? Well, the most important law still today is the law of salvage. So we'll have to talk a little bit about what that is. And then there are some special domestic laws usually. Most jurisdictions today have their own laws to cover their own waters to what should happen with wreck if it is discovered in there. Often they have as a fallback or incorporated into their laws the law of salvage as well, but we'll deal with that with a particular example when we consider the law of Hong Kong. We also now have to today consider the international conventions. As I said, I'll be dealing with these mostly in the second video. That's the United Nations Convention on the Law of the Sea, UNCLOS, and the 2001 Convention to do with the underwater cultural heritage. I will deal with those in the second video. I have to admit now that I'm not a great fan of international law. I'll probably upset my colleagues by saying that, you know, international law is often to many lawyers, I think we just regard it as not really being law. It's more aspirations and hopes. It would be nice if sort of thing. So apologies again to my colleagues who teach the international law to do with commercial transactions, which is of course real law. But other than that, especially when it comes to heritage law, yeah, it's what would be nice if we could do this. That really comes in, even with UNCLOS as such. You know, that's one of the only international laws which I think is probably in this area has some importance apart from the international law to do with salvage. But that's mainly because states want to assert ownership of the waters around their shores. That's why. And of course, we also know that many states who assert ownership of the waters around their shores using the United Nations Convention on the Law of the Sea also then ignore other states' claims to waters around their shores as well. So we can deal with that in the second video. So let's talk about the development of the law of salvage. It's often been said that it is likely that the first ship launched sank. So let's just move on from that and say, yeah, probably the first ship that humans built sank by its nature. The launching ships onto water, whether it's rivers, it's inland waterways, it's at the sea, it's quite dangerous. And these things often do sink. But of course, the thing we should add to that is it's very likely that if something sank, then someone tried to save it. They tried to save the vessel itself because it would be considered to be valuable. They would try and take anything of value away from it. And if it did sink, well, they'd try and get it back if they possibly could, because these things were immensely valuable and the cargoes on them would be valuable as well. So that's I think goes with the idea that the first ship that was launched was sank. Well, yeah, and then humans trying to get whatever it was, the ship itself, the cargo back. And also, let's face it, that this would have been ongoing. If it was known that something of value had sunk somewhere, then people would keep on trying to get it. And again, they would develop technology to try and get this back as well. And of course, if they ever did recover it, it's likely that there was a dispute between whoever recovered it and the original owners as well. And that's really what we're talking about when we talk about the law of salvage. So if we are thinking about the development of the law of salvage, we have to think of one very, very important shipwreck. And this is the shipwreck of what was termed a white ship back in the 12th century. So this is an important shipwreck in the law of salvage. It's also an important shipwreck in the development of the common law itself. Why? Well, the white ship was sailing from France to England, carrying very important cargo. It had on board the son of the gentleman at the top here, that's Henry I of England, and it was Henry's son and heir who was on board this ship. Unfortunately, his friends, the crew, it seems, had imbibed too much French wine, and a disaster ensued. The ship sinks. I think the only person to survive was one of the butchers who clung to some shipwreck, or a cook who clung to some shipwreck. And this is a picture of this, isn't it? A drawing, an illustration of this shipwreck, and also showing the king and why this is important in the law of the common law, the history of the common law. The king is grieving because he's lost his son and heir, and that means he's got a daughter, but daughters are easily usurped from their inheritances, and that's what happened to his daughter, the Empress Maud, because we end up with King Stephen coming to the throne at that point, and what was termed the anarchy, a war between Stephen and Maud, which ends up with, of course, the Henry II coming to the throne, who very important in the establishment of the common law. So also linked into this, why is this important in the history of salvage? Well, because Henry II's wife, Eleanor of Aquitaine, is one of the promulgators of what are known as the rules of Oleron. And the rules of Oleron contain provision for what today we consider to be the law of salvage. It says, if someone is shipwrecked on your shore, if you see shipwrecked goods, merchants there, don't rob them, don't steal whatever is there. You must try to help them. You must try to save their goods. And if you do, you will be entitled to a reward. And that's the basis of salvage. Everyone thinks that when you salve something, when you save something from the sea, it is yours. No, you save it for the original owner, and that entitles you to a reward. That's the basis of the law of salvage. The law to do with salvage has been developed in line with technology. As humans began to explore the seas, to develop, well, actually their exploration of the seas was often driven by this drive to actually try and recover things of value from the seas. We get this development of technology, the diving bell, diving suits with replenishing air, surface pumped air to them, the aqualung, side scan sonar, underwater metal detectors, remotely operated vessels. We're now moving into the 20th century. We moved from the late 17th century through into the 20th century in these developments of technology, which is aided with the salvage of vessels of treasure from under the sea, and have led to developments in the law, because as things have become more accessible, well, of course, as I said before, you end up with more disputes between the people who are recovering things and the original owners as well. So here are some illustrations of old ideas of the diving bell. We have here some pictures of the diving bell, or reconstruction of the diving bell, top right, used in the recovery of cannon from the Vassar. My favourite at the bottom right there, we have an illustration of a diving bell used by Sir William Phipps, an English adventurer who perhaps was one of the first true underwater treasure hunters. Probably his legacy is with people like Mel Fisher and Mike Hatcher, who we'll be talking about in the second video. The development of the replenishable air diving suit, of course, very important. Here we see an illustration of the Royal George, a military vessel, British military vessel, which was sunk. Sorry, it would have been an English military vessel at the time, which was sunk, and a long ongoing process of salvage of cannon and of other things of value from that vessel went on for many, many years, because again, the value of what was on there. We see the first use of self-contained underwater breathing apparatus in the early 20th century, with attempts to salve from the ships like the Lusitania as well. And again, you have to think how, I think, brave the people were who actually went underwater in these particular suits. There were many early disasters involving this technology. So what is the law of salvage then? Well, the modern law of salvage is this. We usually talk about what's called pure and contract salvage. Contract salvage is, of course, when there is an agreement to actually save a vessel and its contents, its cargo, negotiated between the owner of the vessel, the owner of the cargo, and those who are undertaking the salvage as well. Pure salvage, though, this is an idea that to encourage people to try and save vessels, because, of course, as I said before, taking to the sea is an inherently dangerous endeavor anyway. So we needed some sort of, as it says there, economic imperative to encourage the saving of ships and cargo. I'm sure that many sailors would want to save others because they would like to be saved themselves if anything went wrong. But this was the idea: let's give them a reward. If you save a vessel, if you save its cargo, then you're entitled to a reward. So salvage is all about efforts to save ships or cargoes in peril. Treasure wrecks have often in the past been categorized as in peril by those who are trying to recover them. Of course, many archaeologists today would say that it was the treasure hunters were actually the peril to these wrecks as well. But again, maybe we'll talk a little bit more about that in the second video. So the development of the law of contract salvage has, well, that's really linked to the law of insurance. If we think about who the loss often fell upon when a ship sank, it was the insurers. And that meant that early on, insurers such as Lloyd's developed ideas of, we need an agreement which deals with what happens if someone does recover this ship, this cargo, because we're the ones who may have to be paying up on this. So we get the development of the law of insurance alongside the law of salvage as well. We also get some international agreements because we are talking about ships going all around the world. So we're not just talking about domestic laws. We need some sort of international agreement. In 1910, we get the Brussels Convention for the Unification of Certain Rules with respect to assistance in salvage at sea. And this provided the basis for the law of salvage. One important provision, which was changed only in the 1980s, was the concept of no cure, no pay. That meant if you attempted, if you worked at trying to save a vessel and you didn't get anything, you didn't save anything, you weren't entitled to any payment. Now, that may sort of make sense until we get to the 1970s and 1980s, when we get those big oil spills, the oil tankers, and the terrible environmental damage that happened, which of course, again, cost insurers huge sums of money. So the insurers are pushing for a change there in the law. They want to change. What do they want? They want to say, okay, if you make an attempt, you might be entitled to some payment, because they want to again encourage people to try and save these vessels. So that's when we get the 1989 International Convention on Salvage. And that's often been incorporated into domestic jurisdictions and is part of the law of Hong Kong. So how does the law of salvage work in a domestic jurisdiction? Well, let's talk about Hong Kong then, because it's a good jurisdiction to explain how the various aspects of the jurisdiction's laws can work if we have a shipwreck or the identification of wreck or what we might term treasure. So how does that work today in Hong Kong? I put in there that Hong Kong, the islands of Thebes, the Portuguese knew the islands that make up the area of Hong Kong as the islands of Thebes because, well, this area was so famous for pirates. This is a very famous pirate cave on Chung Chau. Hong Kong is inherently linked to the sea. We are a jurisdiction which, of course, has, well, if we think about the island of Hong Kong, the only reason that the British came here was because of the harbour, Hong Kong Harbour, Victoria Harbour. This is a picture of the Maritime Museum. If you get the chance to come to Hong Kong, hopefully you will at some point in the near future, please visit the Maritime Museum. It's a great museum and tells a lot about the story of Hong Kong as it's linked to the sea as well. Hong Kong, when we are thinking about our history, we have to think about things like pirates, tea, and of course, opium. Again, the very reason for Hong Kong being founded as a British colony. Of course, there were people in Hong Kong before. As I said, the Portuguese referred to these waters as the islands of Thieves because of the prevalence of pirates in the area. Such was the prevalence of pirates that, of course, we get that great clearance order moving people out of the land of the new territories of Hong Kong in the 1660s to stop them helping. It was said that they were aiding pirates who were operating in the waters as well. And we have our famous pirates that operated in the waters around Hong Kong, particularly around the island of Lantau. Chung Po Tsai is one of the most famous as well. We've had some very famous wrecks in Hong Kong as well. This is probably one of the most famous. I only put this in so I can put a picture of Roger Moore as James Bond in there as well. No evidence that the wreck was ever used by the British Secret Service, but it would be nice to think so. We also have other evidence of our maritime past, which actually shows a lot of the problems to do with our underwater cultural heritage in Hong Kong. This is a demi-culverin, which is on display in Exchange Square in Hong Kong. It was found during the reclamation work that went on for the building of Exchange Square. The problem is, of course, we don't really know where it came from because this was actually a landfill site anyway. The culverin probably had come in with landfill, so we don't know where it came from. We know a little bit about the culverin because we know about the history of these particular types of guns, but we don't know where it originally came from. And that's one of our issues in Hong Kong to do with our underwater cultural heritage as well. We have reclaimed so much of the sea that maybe some of our underwater cultural heritage is under that reclamation or has been disturbed by previous reclamation works as well, when people weren't so conscious of the importance of underwater cultural heritage. The legal framework for the operation of identification, protection, ownership of shipwrecks, of any form of underwater cultural heritage in Hong Kong is made up of these main factors. First is that our jurisdictional waters are 3 miles. So Hong Kong, of course, has its own jurisdictional waters as a special administrative region within the waters of China. We also have 3 very important ordinances. The first is the Environmental Impact Assessment Ordinance, which mandates, as of 2007, that every capital project, every big development project in Hong Kong must have a heritage impact assessment. So this should protect our underwater cultural heritage if we have development projects going on in Hong Kong. It's been referred to as the gold standard in Asia, and it's pretty ineffective, but never mind. Maybe we'll mention that a little bit later on, but it would be nice. Again, it's a nice aspirational principle in our laws as well. Nothing to do with the archaeologists. Think about the people who actually implement this policy. The Antiquities and Monuments Ordinance, very important, and I'll give you a very brief outline of that. Of course, in my class, I would deal a lot more with all of these ordinances. And then finally, the Merchant Shipping, Collision Damage, Liability and Salvage Ordinance, a very easy a name to remember, which incorporates the International Convention on Salvage 1989 into our laws of Hong Kong in its Schedule 1, with some important provisions specified there. We'll come to that very shortly. So the Antiquities and Monuments Ordinance, designed for terrestrial antiquities and monuments, drafted actually in the early 1960s, only came into, well, gazetted in 1970, came into effect in 1976, at a time when, let's be honest, underwater archaeology was very limited in many ways. And there was really, I would suggest, again, probably offends many archaeologists, a lack of the appreciation of underwater cultural heritage at the time. So British administration at the time brings in this Antiquities and Monuments Ordinance at the behest mostly of archaeologists who are concerned about land archaeology. And again, to be honest, the colonial administration did this more, I think, to keep people quiet than rather with any idea of really fulfilling the stated purposes behind the ordinance. It does include, though, that it covers discovery in, on, or under land or sea, or attached to or within the fabric or foundations of structure in, on, or under land or sea. So in theory, it should cover anything that is found in the waters around Hong Kong. It offers 2 forms of protection, therefore, for underwater cultural heritage. That is by recognition as an antiquity or relic, so it has to come within the definitions of those in the ordinance, and that really specifies that we're talking about things created, human made or affected things before the year 1800. No one knows why it's the year 1800. It just seems to be one of those sort of arbitrary dates that was sort of plucked from the air as part of the ordinance. And the second way is if the government designates the wreck, the area, whatever has been found underwater, as what's termed a proposed monument or a monument under the provisions of the ordnance. Again, I will go into more detail about this in my course about how this actually works. So what's its effects then? Well, there seems to be some immediate protection if a wreck that was pre-1800 was discovered in the waters of Hong Kong, because it would be recognized as an antiquity or a relic. However, if we think about the history of Hong Kong, we're really thinking colonial-wise, the use of the harbour, it had been used for a long time before the British took over, but we're talking about 1841. So we could have ships that were made post-1800 that are discovered in the waters of Hong Kong. They will not be covered by the Antiquities and Monuments Ordinance unless they are designated as a proposed monument or a monument. So they don't get any automatic protection. And if they're not covered by the Antiquities and Monuments Ordinance, well, then the law of salvage will apply to that wreck or treasure. The law of salvage in Hong Kong is covered by the Merchant Shipping Collision Damage Liability and Salvage Ordinance. As I said before, the name just trips off the tongue. And that incorporates in Schedule 1 the International Convention on Salvage. The important provisions for us to remember is this: if we've got something termed an abandoned wreck, if we've got something we can't identify the ownership of this wreck or whatever else, well then the default principle is that the Hong Kong government is entitled to all abandoned wreck, which of course is a follow-on from the common law, which recognised as a crown prerogative wreck in England, and that would apply also, or should have applied also in Hong Kong as well. The important other things to remember: the provisions of the convention, Hong Kong opted for this inclusion. The provisions do not apply when the property involved is a maritime cultural property of prehistoric, archaeological, or historic interest and is situated on the seabed. Well, that would probably come under the Antiquities and Monuments Ordinance anyway, but that just emphasises that these things are excluded. The other thing to remember is, of course, this important provision, which again, many states incorporate, mostly because they want to protect their own wrecks. Article 4 says that state-owned vessels, well, the convention does not apply to warships or other non-commercial vessels owned or operated by a state and entitled at the time of salvage operations to sovereign immunity under generally recognised principles of international law, unless that state decides otherwise. This is something that is important to many of the former maritime powers. They've been very concerned that that people don't just go and exploit the wrecks of their state vessels that may be all around the world. We've had some notable discoveries in Hong Kong back in 1974 during the British colonial time, when the High Island Reservoir was being constructed. A Ming Dynasty shipwreck was discovered. Unfortunately, this was just after the gazetting of the Antiquities and Monuments Ordinance, but just before it came into effect, so it didn't actually gather the protection of the Antiquities and Monuments Ordinance, and the colonial administration did the sensible thing and just concreted over it to protect it for the future, because there's a time limit, you need to carry on. This is a big capital project. But more recently, we've had some more concerted efforts to actually map out our underwater cultural heritage in Hong Kong. Bill Jeffries has been running a group with very limited funds to try and identify wrecks and sites around Hong Kong, and they've been successful in recovering some important artifacts. Important often because the showing of them will emphasize to the people of Hong Kong that we have got some important underwater cultural heritage out there. So here we see Bill at the Maritime Museum looking at a cannon that they recovered. I think they recovered 2 cannons and one of those stone tang anchors as well, which I think are now on display in the Maritime Museum. And of course, the other notable discovery in recent years is, well, we're not sure. At the time I'm making this, which is August 2021, it still hasn't been decided whether the lump of metal that was found many years ago now in the Victoria Harbour near to Wan Chai is actually the remains of HMS Tamar. It seems that most of the archaeologists, the historians are sort of involved, say, yes, it is, but for some reason, we're not getting a definitive identification of it. The Tamar would be an interesting case, legally anyway, because of course the Tamar would be a state vessel, and it's post the Antiquities and Monuments Ordinance. It's not subject to any designation. It wouldn't be subject to normal law of salvage because it is a state vessel as well. So there are lots of there are lots of issues with Tamar, which make it an interesting wreck, if it is Tamar. And most people seem sure it is. So how should the law work in Hong Kong? Well, let's start by saying we're talking about the law in the waters of Hong Kong. As I said before, we have a 3-mile jurisdictional limit around the waters of Hong Kong. Here is a map of the islands of Hong Kong showing you that jurisdictional limit. And then how would the laws work? Well, anything found in those waters would be subject to this diagram. So like all good diagrams, this is intended to completely confuse you. So let me try and walk you through the diagram if I possibly can. Shall I try and annotate? Let's find a color that might actually work. Would black work here? Let's try. But we start at the top left here. The starting point, I think, should be the specific law which deals with any antiquity or monument found. So the Antiquities and Monuments Ordinance. And that would say, first things, the question to ask, is it an antiquity and or a wreck? So is it something that was manufactured by humans before 1800? If it is, well then it seems to be immediately subject to the protection of the Hong Kong SAR. Probably ownership of it, well, the ordinance specifies ownership of it would vest in the HK SAR. If it's not, next question to ask, has it been designated as a proposed monument or a monument? If it has, again, it's subject to the protection of the HK SAR. If it hasn't, we need to talk about the law of salvage. First thing to say is, can we identify the original owners of the wreck or whatever we have found? If we can't, next question, is it maritime cultural property? If it is, well then again, it seems that that would be subject to the Antiquities and Monuments Ordinance, so that should have engaged already, but it would become vested in the ownership of it would be vested in the HKSAR. If not, well again, because of the default that anything that is not identifiable is vested in the HKSAR, it would belong to the HKSAR as well. If we can identify the original owners, what things do we want to know? First of all, is it a warship? Is it subject to, is it a state-owned vessel? Because then it would be subject to that concept of sovereign immunity and specified, of course, in the ordinance as well. Ownership of it vests in that state unless they decide to say, we don't want it. If it is not a state-owned vessel, next question is, has it been abandoned? If it hasn't been abandoned, then of course ownership of it still vests in the original owners. Usually that would be in the insurers who paid out as well. And if it is recovered, then salvage should be payable on that. If it is abandoned, well, of course, then ownership would vest in the HKSAR. As we can see, all arrows here mostly lead not to Rome, but to the HKSAR, except for those exceptions, as we've seen around there. So hopefully that sort of didn't confuse you too much. Let's just clear the drawings and then we can move on to the next slide, which will say, these are my contact details. The next video that I'm going to make is a sort of brief overview of the international law to do with shipwrecks, treasure, etc. But if you have got any questions at all of what I've been talking about here, or any comments or any information that you'd like to share, well, there's my email address, and I'll be very happy to hear from anyone. Thank you very much, and hope to see you at some time in the future, maybe at one of CUHK Law's public seminars, or you never know, maybe on one of our courses. Thank you. Bye-bye.